I'm happy to provide you today with a CLE, not from me, but from my partner, Rosa Feeney, and our senior counsel in the coverage unit of Smiley and Smiley, Jocelyn Seitter. Both Rosa and Jocelyn are experts in insurance coverage and specifically declaratory judgment actions. They just did a live CLE that I thought was just so fantastic, and the information is just really important, and I figured I would share it with you. So you can get CLE credit for this episode, just like you have for many of the other ones. Just look for the codes and fill out the forms in the description, and enjoy this wonderful program from Rosa and Jocelyn on handling declaratory judgment actions.
Today, we're going to talk about declaratory judgment actions. And there's so much to talk about that what we decided to do is we're actually going to split this into a part 1, which is today, and then a part 2, which is probably going to be in like February. And today we're going to talk about the who, what, when, where, why, and how of declaratory judgment actions, okay? And then in a couple of months, what we're going to do is we're going to actually talk about the actual discovery process. We're going to talk about the depositions in declaratory judgment actions. We're going to talk about experts in declaratory judgment actions in federal court or even state court, expert depositions, and motions for summary judgment. Okay, so I wanted to fit it all in, but it was impossible because there is really a lot to talk about on these cases. So let's start with the what. So what is a DJ action, right? So a DJ action is just a typical civil litigation where the court is asked to determine the rights and obligations of the insurance company and the insured, okay? But there are different types of declaratory judgment actions. So the one thing that's common with civil litigation is it's the pleadings, it's the discovery documents, paper discovery, then there's depositions, sometimes the expert discovery, summary judgment, and trial. And that's consistent across the board. So procedurally, it's the same thing. But there are different types. So for example, and I'm going to start off with this case sample so that we're going to talk about it throughout the presentation. So let's say you have an injured construction worker, and this is typically where we see like most of the disclaimers. You have a construction worker under New York labor law who's injured, and he sues the owner and the general contractor, okay? The owner and the general contractor then third party in the employer, all right? And sometimes they'll even bring in another subcontractor. So let's call that subcontractor number 2, okay? So in that particular type of case, if there's a disclaimer and a coverage issue comes up, then what's going to happen is going to be a separate DJ that's going to be filed. And we'll talk about that, whether it can be in the case or separate later on. But there'll be a DJ started. And in that DJ, let's just say the owner and the general contractor are looking for coverage from the employer's insurance company, right? The owner and general contractor are paying defense costs, or their insurance company's paying it. And so when they file the suit, this DJ action, saying we're an additional insured under your policy, they're not only seeking coverage, they're also seeking their defense costs. Okay, so that's an example of where a declaratory judgment action has a monetary component, to it. Same thing, for example, let's just say we have a case where an insured is battling with their insurance company over a fire and how much the insurance company is going to pay. And he's got to start this action, right? Sometimes those actions involve questions of coverage, right? So that would be, you're asking for a declaration as to a question of coverage. But sometimes there's also a monetary component. The insured wants more money. He didn't get enough money from the insurance company. Okay, so while declaratory means you're asking for a declaration, it can also involve money. So that brings us to the second question, where to bring your DJ action. All right, so you can bring it in federal court if you have the proper jurisdiction, pursuant to the Federal Declaratory Judgment Act, which is 28 U.S.C. 2201. Not to bore you, but it's in the materials. and then CPLR 3001, which is where the state authorizes the declaratory judgment action, okay? Let's talk about the state first. And I think that picking your venue is really important for a number of reasons. And we're going to go over the pros and cons of it. So in state court, as I said, you have the complaint, you have paper discovery, you have depositions, you have summary judgment and trial, right? What I normally do is I commence my DJ actions in the same court that the underlying action is pending. All right, so, and I want to just explain what underlying action is in the event that somebody doesn't understand what I'm talking about. Underlying action means, for example, the example I gave, the injury case, right? The plaintiff, and now there's the general contractor and the owner, and that's the underlying injury case. And then the DJ is the related case. So what I often do is I will file in the same venue, the same. So for example, Kings County, let's just say, and when I go to file the RJI, I will mark on there that there's a related case so that you have a chance of getting the same judge, but you might not. I find that it's very helpful to do that. And for example, in Kings County, one of the great things is that a lot of the labor law cases get assigned to Judge Devin Cohen, and he is very knowledgeable of not only labor law cases, but he's also very knowledgeable of coverage. So what happens sometimes is, even though I'm before a completely different judge because he doesn't get the DJ actions, a lot of times we end up before him at a settlement conference to discuss the issues, and he understands the coverage pieces of it. Okay, and I find that it's helpful even if the judge isn't really that familiar with coverage, because you're in the same courthouse and the judges talk to each other and they want resolution. And I think it brings everything to a quicker resolution and a potential for a global, resolution, right? A lot of times these cases end up in mediation, right? And which you can also do through the courts, by the way. But you could do it privately, through one of the, NAM or one of the other ones. But you can, at least if you don't want to go to mediation outside of the court system, that you can bring the parties together if everybody's in the same courthouse. Now, just because you file in state court doesn't mean your case is going to stay in state court. The insurance carriers, many of them, like to remove these cases to federal court. All right. So if you find your case in federal court, obviously you have to know federal procedure to litigate a case in federal court. And it's very different, in my opinion. First of all, it's much more expensive than a state court case. The federal DJ actions, you have same thing. You have, pleadings, paper discovery, depositions, expert discovery and depositions, summary judgment, and trial. And we're in the middle of one right now where we have these expert disclosures and depositions that we just completed last week. And it's a lot of time and a lot of money to litigate those cases. So in terms of money, if that's a concern for your client, then federal court is not the best place to be. However, if you want a quick turnaround, it is a good place to be, because they push the cases a lot faster, right? So you're attending these conferences constantly. You have to keep on the discovery schedule. You have to be within a certain, and these cases oftentimes end up moving a lot faster than the underlying action, which can be a problem. And I'll tell you why it's a problem, because sometimes if you're in a DJ action and you have your case started, then if your case proceeds prior to the other case, there could be an issue with whether or not your case is ripe for resolution. So we're going to talk about that in a minute. But what I want to just touch upon is, if you're going to file your case in federal court, you have to have, you can do it pursuant to the Declaratory Judgment Act, but you can't get jurisdiction that way. Jurisdiction is a separate thing. So you need to still establish that it's diversity of the parties and $75,000 the amount of the controversy. All right. So diversity can get tricky, and that's like for another presentation. But if you're suing, let's just say an insurance company is coming after an LLC, it's actually the jurisdiction of the venue. I'm sorry, the domicile of the members that determines whether there's diversity. And I actually had a case where nobody was challenging it except for the judge, and the judge said, "We want you to send a showing that you have jurisdiction." And so again, I had to prepare a letter motion explaining why I had jurisdiction. Now, when you're talking about the $75,000 in controversy, the way that's determined is there's different schools of thought here, but the way it's determined is what's the value of the underlying action, right? So, for example, if the carrier is going to be subjected to $1 million damages award on the underlying action, then you can argue that the case is worth $1 million. The amount in controversy is $1 million. Or if it's a policy limits case and the carrier knows they have $5 million, that's the amount in controversy. Okay, so it just depends on the kind of case it is. The other thing is that defense costs can be used to satisfy the amount in controversy, right? So if the defense costs being incurred in the underlying action for which whoever it is, whether it's a defendant or their insurer, is seeking reimbursement, that can act as the amount in controversy. Okay, so that's the where. Now, when going back to how fast a DJ moves, one of the problems that you can have if you start the case and the case moves quicker is that you will be in a situation where, let's just say, for example, it's an intentional acts case, right? And the carrier decides that they're going to defend the insured under a reservation of rights. And then they start a DJ saying we don't owe any coverage. So what's going to happen in that case is if your DJ goes faster than the underlying action, you might not have all the facts in place to establish that you don't have a duty to indemnify, because the question of whether or not it was an intentional act may still remain open because of the underlying action. So these are just some of the things you have to balance out and work with when you're doing this. All right, so now who can bring a DJ action? All right, so an insurance carrier can bring a DJ action against their insured. An insured can bring a DJ action against their insurance carrier. An additional insured can bring an action against their insurance carrier or whoever they're claiming additional insured coverage, whoever that carrier is. All right. And the carriers, the insureds can bring the case, and oftentimes the carriers for those insureds can bring the cases because they have a monetary interest in this, right? They're laying out all these defense costs. However, and this is a question I get all the time, in my practice, just as a little backdrop, we represent injured plaintiffs in DJ actions, we represent policyholders and defendants in DJ actions, and we represent a few insurance carriers in DJ actions. Okay, so we have the gamut. We see all sides of this. And pursuant to Insurance 3420, an injured claimant or any other party cannot bring a DJ action unless there's a judgment that remains unsatisfied for 30 days, okay? So if you're a plaintiff and you get a disclaimer in your case, and you could be left without coverage, you do not have a right under Insurance Law 3420A2 to commence the DJ until you have the judgment, okay? Let me give you another example. If you're a defendant, let's just say now subcontractor number 2, right? He's got cross claims against the employer. He cannot, that defendant, it cannot commence a declaratory judgment action against that individual, the employer's carrier. They don't have a right. I mean, this is something that I really feel should be changed. There is a very limited exception that the legislature made. And that limited exception is when the issue is whether or not there's a late notice disclaimer and it's improper. If there's a late notice disclaimer, then then an interested party can commence the DJ action before the judgment. However, the only issue is the late notice. So when you get a DJ action, a disclaimer of coverage, usually there's so many different reasons why they're disclaiming. It's not just late notice. So you're only limited to that late notice defense, which is just really doesn't work in most cases. That's not the only basis for the disclaimer. I was actually able to do that on one case because that was the issue. It was late notice, and as a plaintiff, we commenced the DJ action against the carrier, and and we got the case resolved. It puts pressure on people, and the case was resolved. But that's one of those things where I'm working to try to change that legislation because I feel that it benefits not only the injured claimant, but also the co-defendants in a suit. The plaintiff is left litigating this case without knowing whether or not they can ultimately get any money out of it. And the same thing for a co-defendant. They want to enforce their cross claims. They can't because they can enforce it in the underlying action, but if there's no insurance, there's no insurance. Okay. So the one thing I do want to say is not all is lost if you can't commence a DJ action. All right. We often get brought into these cases and after the disclaimer is issued. So a plaintiff's firm or an insured, they'll get a disclaimer and then they send it to us and say, what are we supposed to do here? Is this right? Can this be enforced? And then what we get involved in, and you can get involved in if you handle these, is you can get involved in what I call is pushback letters. So what you want to do in those cases is you want to review the coverage position. And if you feel like there's a hole in the coverage position, I prepare this pushback letter, which is basically an outline of our legal position. And I send it to the other carrier. And I oftentimes will also send it to, if let's just say that particular defendant who's carrier disclaimed, I will send it to them. I will send it to their lawyer if they have one and say, please forward this to your client to show them, look, you have a viable position here. You might be able to overcome this disclaimer of coverage. So I think that there are other ways. Another thing that I often do if the insured is not represented in the underlying action, which happens quite often, I reach out to the broker and I'll call the broker and say, listen, we're going to push back on this. I'll send you a copy of my pushback letter, talk to your insured and tell them that they need to get coverage counsel on this thing. And that does work. And what happens when you send these pushback letters is you also are going to likely get other attorneys engaged. So now you're not just going up against the carrier, you're going up against an attorney who understands coverage law and who you can actually discuss the law with and how to proceed. Okay, so the next, and I know we're kind of going through this fast, but it's there's a lot of material. So the next issue is how do you start the DJ, the actual technicals of how you commence it. And Jocelyn has commenced quite a bit of declaratory judgment actions. She does that for us. And, there is an art to it. And so I am going to pass over the microphone to her so that she can let us know how, some of the tricks about commencing a DJ action.
Thank you, Rosa. Hopefully I'll do this justice for you. So once you've decided that commencing a DJ action is appropriate, you need to determine which parties to name, who are the proper parties to pursue coverage for or from, or who are the proper parties to deny coverage to. This is going to depend on who your client is and what type of relief they're seeking. We typically see 3 different scenarios. First one, if your client is an insurance carrier and they're seeking a declaration of no coverage against their own insured. Obviously, you're going to name their insured. But as Rosa was discussing, the underlying injured claimant is also an interested party. And they will have the right eventually to commence their own DJ action against your client insurance carrier once they've obtained that judgment and it's gone unpaid for more than 30 days. So typically, to avoid having to litigate the coverage issues more than once, you will also want to name that injured person or other interested party in your complaint. This can be advantageous too, because in some cases they have facts or testimony that might help your case. We do see often that injured claimant doesn't answer the DJ. We consider this to be a mistake on their part, although it can be beneficial to our clients, because once the injured claimant is named in the DJ, their rights are going to be affected by the outcome. So answering would give them the opportunity to have their opinions and arguments heard. And again, for your client, it avoids that double litigation. The second scenario we see is if the client isn't insured and they're seeking a declaration of coverage against their own carrier. In this case, you would want to name their carrier. It's typically their primary insurance carrier. But whatever carrier issued the policy that your client is seeking coverage from. But you also want to name any and all excess carriers that may provide coverage to your client for the loss. Excess policies typically are follow-form to that underlying primary policy, but they might also contain their own exclusions. So this way you're litigating, again, everything all at once for your client. How do you find these carriers? Hopefully your client can provide that information. If not, you could reach out to their insurance agent or their broker. In this scenario, you don't need to name the injured claimant as a party because you're only seeking to protect your client, the insured's rights under the insurance policy or policies. However, as the injured claimant's interests may align with those of your client because they both want there to be insurance coverage available. And because that injured claimant may have facts that support your position, if you can get them on board, it can be beneficial to name them in the DJ action as well. The third scenario is if your client is seeking additional insured coverage from another party or other parties. Here your client might be an insured or it might be another insurance carrier. Sometimes you end up working for both as their interests are typically aligned. They both want coverage from someone else. Your client might also be a party who, for whatever reason, doesn't have insurance coverage of their own and now only has the option to get coverage through an additional insured mechanism. In a scenario where your client is seeking the additional insured coverage, you need to name the party or parties from whom they are seeking coverage and those parties' primary and excess carriers. You do not typically need to name the injured claimant in these cases. So how do you identify the primary and excess carriers? Ideally, your client has this information. We typically try to get a copy of the contract between the client and the other party or parties under which they believe they're entitled to additional insured coverage. And this comes up most commonly in labor law cases, as you're probably all aware, under workers' compensation. If a party is injured, they don't have the right to sue their own employer. So what we'll see, for example, is a subcontractor's employee gets hurt on the job, they can't sue the subcontractor, so they'll sue the general contractor that hired the sub, and they will sue the owner of the project or the construction manager or both. I joke that this is kind of a way of trying to do an end run around that workers' compensation bar because typically that general contractor, that owner, that construction manager, they're going to have contracts that send that indemnity back down to their employer. So although, Bob Smith or Jane Doe can't sue her own employer, her own employer, they sue everybody above, and then all those parties turn around and sue that subcontractor for coverage. And so hopefully you've got those contracts. And if you're really lucky, those contracts will include copies of the certificates of insurance for that subcontractor. And this is just a one-page form that says who their insurance companies are, the dates of the policy the dates the policies are effective, the policy numbers, and the policy limits. If you don't have access to that, one of the things I like to do is check the underlying action because a lot of times there will be insurance disclosures. Sometimes that information is viewable on NISAF. Sometimes if you're really lucky, you'll be able to get a copy of the policy or policies. If you don't have access to that, you can review the tender correspondence, especially if there's disclaimers, reservations of rights, things like that, that'll typically have the carrier names on them. They'll also have the policy number, the claim number, things of that nature. Again, frequently the policy limits are there too. You can also always reach out to defense counsel in the underlying action and see what information they might have for you. So those are just a few different ways to get some information so you know who to sue. Once you've
I could just
identified
interrupt you
them,
1 second, Jocelyn.
yeah,
One of the things I want to
absolutely.
say on this point is that sometimes, you start in the underlying litigation, and you don't have discovery yet, so you don't have the certificate of insurance. You don't know who their carrier is going to be, and the only way to get that information. I mean, there is the Insurance Disclosure Act, which people don't really pay attention to, where it's supposed to be an automatic disclosure in 90 days, but that doesn't happen. So we often find ourselves kind of pushing on defense counsel, like, hey, can you push for the disclosures, the only other way to get it is if for some reason you know who the broker was, or can find out who the broker was. I've gotten it like that as well. And don't be afraid to, call these brokers. They want to help their insureds get coverage, so they're very, very cooperative when it comes to that kind of thing. But again, generally you're at the whim of the parties to the underlying action. And sometimes the carriers they get access to these things, through other contracts or other cases that they've had. So that's something to look at too. Okay, Jocelyn, go ahead. I'm sorry to interrupt.
No, that's okay. Appreciate it. Again, so once you've identified them, now you've got to serve them. And for insurance carriers, that can be a little bit tricky. For carriers that are admitted in New York State, we typically serve them through the New York Department of Financial Services. The New York DFS website has an insurance company lookup feature. You can search the beginning part of the carrier's name, and as long as the carrier is admitted in New York, you'll find their address for service. And I will drop the website for that into the chat so everybody has it.
If you're joining us today via podcast, the first attendance verification code is INS 918. That's INS 918.
You do want to confirm that the carrier's name matches. Typically, you do this by checking the name either on policy declarations, the tender correspondence, the certificate of insurance. And the reason you want to check that is because, as we all know, insurance companies tend to have multiple subsidiaries or different company names. For example, I recently had a case where one of the entities was needed to be served in New York, but if it had been a different carrier that issued that policy, we would need to use a Connecticut address for service. And the only difference between those two company names was one ended in US Inc. and the other one did not. So you always want to make sure that you're confirming that you're serving the right entity. On the summons, you'll list the address for the carrier and then indicate that it's being served via DFS. DFS, I think, charges $40 for service, and you'll need to send the specified number of copies of the summons and complaint with your $40 check. For carriers that are not admitted in New York, so if you go to that DFS website and the carrier doesn't come up, that typically means they're not admitted here. So you'll want to go to the Excess Lines Association of New York website, which is www.ilani.org, and I will send that link as well. You'll search for them there, and again, you'll find their address. In this case, you'll want to arrange for personal service. Whenever possible, it's a good idea to also send courtesy copies of the summons and complaint to all parties via email is ideal. Typically, I'll use NICEF to obtain the contact information for defense counsel in the underlying case. I'll also send it to the carriers directly. If I have the claims adjuster's information, I'll email them directly. If I don't, you can go to the carrier website. There's typically a claims email address, and you can just send it that way. Service via DFS in particular can be quite slow, so sending the courtesy copies can also get your case moving faster, which is obviously an advantage. Finally, I just want to note whether or not you end up naming the injured claimant in the DJ, you may also want to reach out to their counsel just in case they have information that might be helpful to your case. And again, you can usually get their information off of the underlying action in NICEF.
and just to add to that, one of the things that I do is when I start the DJ, if I have the injured claimant, the injured plaintiff in it, or I represent the insured and I have the injured claimant in it, I will call them, the attorney, the plaintiff's attorney, and I'll let them know, listen, this DJ is going on. You really should get involved. Or even if I'm the plaintiff on it, I call them and I ask them if they'll accept service, because a plaintiff's lawyer generally does not want their client to receive this lawsuit that they're not going to understand what is going on in this case and why they're being sued. So they'd rather just accept the service. And, I, again, encourage plaintiffs' firms not to sit back when you're named in a DJ. You have a voice and you can be heard. And in those cases, the injured plaintiff is aligned with the defendant, because all you want is coverage at that point. So, oftentimes I find myself, like, for example, when I have plaintiffs' firms that send me, cases for coverage and I represent their clients, I often find that I'm working very closely with the defense counsel for the insured, so that we are aligned in our position and we're not, I'm not saying one thing and he's saying something else, right? So I think it is very important to keep the plaintiff's lawyers involved in this case, because ultimately, they're the ones that are going to suffer, really, if there's no insurance. So in furtherance of what Jocelyn was saying, you really have to be persistent. When I file these DJs, like, you just can't file the DJ and then just let it languish. And if you can do, in federal court, you won't be able to do that. But in state court, you can. And so, I think it's best to keep it on a tight diary. And we talk about this all the time in our meetings. I'm like, if it's going out for service, put it on a 3-week diary. And then not only do I send it to the carrier, whoever it is, the adverse party, via emails and via regular mail, I'll follow up and I'll send it again. And I'll send it to defense counsel and I'll send it again. And you got to get their attention. And most of the times, insurance carriers do not want to default. So I had a case not that long ago where there's a carrier that, I have kind of a history of having issues with, because I represent this one particular client, and they weren't answering the complaint. And I knew, that something's going on. So I reached out to the defense lawyer and I'm like, that the carrier is not answering the complaint. And look, is a default okay? Maybe, but they can move to vacate the default within a year. I think you're just elongating the length of the case. It doesn't pay to wait. Just bring the issue to a head, and it also helps with the negotiation process of trying to get the cases settled. So the next thing I want to talk about is when to bring the DJ. All right. So the case starts, and now the disclaimers start flying, right? Once they get served, everybody gets copies of these disclaimers. And a lot of times what I see happen and is that, for example, these disclaimers are out there and people are looking at them and reading them, but they're not really paying attention. Like, oh, well, it's not my client, and they put it to the side. And then all of a sudden, it comes to time for trial, or your case is on the trial calendar. And all of a sudden, you see that they're like, wait a second, we need contribution from that other defendant to settle this case. But there's been no DJ action filed. So there's no coverage and nothing happening. So I'll get these cases basically on the eve of trial to start a DJ. Do we start the DJ? Yes. And it does have some force behind it, because, the carrier knows, well, wait a second, now we have a DJ we have to deal with. And even if this case settles or doesn't settle, they could come after us on this DJ, right? But it's not the most effective way to do it if you really, 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 really want to settle the case. So I find that the earlier you can bring that DJ action, or start the process of bringing the DJ action, the better. So let me go back for a second. So if somebody comes in to us and says, here, we have this disclaimer, what are we supposed to do with it, right? My first reaction is not commence a DJ, because that's ineffective. my first reaction is, let's review it and let's prepare a challenge letter, a pushback, as I call it, and explain why they're wrong. And I will tell you that probably 50% of the time, we will get them to basically agree with our position and agree to defend and or indemnify or a reservation of rights. But I'd say about 50% of the time. So DJ is not your first, course of action on these things. You really should try to resolve and settle these cases. So after, let's just say you're in one of these construction cases, right? And you send a tender, right? The owner and the general contractor's carrier sends a tender to the employer's insurance company, and they don't respond. And then we send it again, and they don't respond. Third time, no response. Okay, now you got to start the DJ action. Nobody's listening. Nobody's responding. You sent it by email. You sent it by regular mail. Okay. Then it's just time to do it. And that usually wakes everybody up. But I definitely recommend engaging in that process. The other thing is, I also recommend, and I've also done this, is if you get a response, but the response is no, we're sticking by our disclaimer of coverage, then my recommendation sometimes is, do you want to have a coverage mediation? Right? Because a coverage mediation with somebody who really knows coverage is sometimes very, very useful, because they're going to tell it as it is. And they're going to say, look, you're going to be found to have a duty to defend. Just defend them under a reservation. And it really saves a lot of money in the end. I didn't used to know these things even existed. They didn't used to exist. But there are several people who do them now, and I find them particularly effective. When we go to mediation, for example, global mediation, with the underlying action and the insurance action together, which happens quite often also, which I think is very good. It's very good. It is very good. And if there's a possibility of getting the case settled, the whole thing globally settled, that's a great avenue to take. But if there's no way that underlying injury case is getting settled, for example, let's just say the demand is like $30 million or something like that, right? And there's like 10 million in coverage. And it's probably, and you're pretty sure this case is not going to settle just for the coverage piece of it. Then just a coverage mediation isn't going to work. Then you're going to need to do a global mediation, because you're going to need either personal contribution from those defendants to get this thing resolved. All right. But I still recommend mediation. Now, the other thing with the when, and I touched upon this before, is what ends up happening sometimes is that the DJ moves too fast. So the underlying action is just slow and it's moving way too fast. So, what do you do in that circumstance? I mean, if you need to, you could try to slow it down. There's been situations where, I don't want to do this, but sometimes I've had to discontinue without prejudice because the DJ can't go forward until we have the information from the underlying action, right? And again, if you're a defendant in the case, you don't want to be deposed twice, right? You don't want to be deposed in a DJ and now deposed in the other case, because you'd have conflicting testimony. So you really want to bring all this together and do it all together. Now, let's talk about why you're going to bring it. And, I wanted to talk about one other thing that I think I missed when we're talking about the how. What I wanted to say is there are, so you can have these standalone DJ actions, right? But then sometimes you can have a DJ action where it's a third party action in the injury case, right? So again, back to our example, you have the owner and the general contractor who are seeking additional insured coverage under the employer's policy. They can actually commence the DJ against the carrier as a third party action in the injury case. Now, you might get into motion practice because they're going to move to basically sever the actions, saying that you can't have insurance issues in a personal injury case, and which is true. But I've been successful in some cases saying to the court, yeah, but the discovery is duplicative. So let's consolidate the cases for purposes of discovery and then sever for trial, right? And that seems to appease some. Some judges don't want to do that at all. They don't want the DJ involved in the case at all. And then your case is going to get severed. So the next thing, the next question, the next issue is why? Why would you bring a DJ action? So obviously we already talked about what the issues are and what you want to bring to the forefront. But the truth is, I think the DJ action puts pressure on the other carriers to make a decision, right? So a lot of times, for example, we're going to go to these global mediations, and whoever hires me says, let's file this DJ action before the mediation. And I agree with that strategy, because then that means you're serious, right? You're filing this thing and you're serious. You're not going to just walk away if this case isn't resolved. Okay, so I do think that declaratory judgment actions have a lot of benefit, but as I'm going to say, they can be expensive and very, very time consuming. Okay, so last thing I want to talk about, we have about 10 minutes, is I want to talk about the impact of default judgments in declaratory judgment actions. All right, so, and personal injury actions too. So one thing I tell my personal injury clients is, they ask me this all the time: should I take a default against the defendant? They're not answering. And my answer is, it depends. If we feel that the disclaimer is flawed, that we can overcome that disclaimer of coverage, then you could take your default and then you can go after the carrier. But as soon as you take that default, what's going to happen? The carrier is going to disclaim, because now there's been a default judgment and they're prejudiced. So under the Insurance Law 3420, there are these notice requirements. And I'm just going to step back a little bit to explain this whole thing. There are notice requirements. So you have to place the carrier on notice, and then they have to disclaim in a timely fashion. And if you don't place them on notice within 2 years of the accident, okay, then you have to prove that they're not prejudiced. If you commence the if it's done within the 2 years, okay, then the carrier, if they disclaim within the 2 years, they placed you on notice within the 2 years. That's what it is. They place you on notice within the 2 years, then the carrier has to prove they were prejudiced, except when there's a default. So when there's a default, it's an irrebuttable presumption of prejudice. Okay, so you do not want a default if there's a chance of getting coverage. So as a plaintiff's attorney, I would do everything in your power to try and get the carrier involved and try and get them to put in the answer before you file this default. Now, let's talk about, and the last thing we'll talk about is defaults in a DJ action. So an insurance company is not required to defend an insured in a DJ action. They are only required to provide defense and indemnification in a claim for bodily injury or property damage. So that's the underlying case, not the DJ. So what happens is, and I have a case like this right now, I've had several, they file the DJ action, and now you're the plaintiff. I represent the injured plaintiff in the case. And they name me, they name my client. We're going to answer. But now the insured doesn't answer. And now they want to take a default against the insured. So what does a default mean, right? A default means there's liability, that whatever they alleged in their complaint is the truth, right? They said that the insured breached these provisions and that there's no coverage. But now you're a plaintiff in the case and you have an interest in this. And you're saying, wait a second, you can't take a default against them. I'm here, I get to litigate also, and I get to litigate the issues. And just because you take a default against them, it shouldn't be held against me, right? And this is a really tricky situation because a lot of times when these cases are going in for default motions, they're in a default part. So it's not a coverage part. So they don't have that background to understand declaratory judgments and what that means, right? So in that particular case, what I ended up doing is I ended up opposing their motion to take a default, explaining to the court why I believe they can't take the default. Because there are cases in all 4 departments in New York that say that default judgments and declaratory judgments actions are disfavored. And the reason for that is that the carrier has to actually prove there's no coverage. You can't just say it was on default, and particularly where there's a plaintiff who's stepping in, right, and saying, wait a second, I have a meritorious defense here. Here are my issues, right? So it's very important in those cases to, as again, this is another example. When you're a plaintiff, you need to get involved in these cases, because if they just take the default, that's it. The default's taken, and then there's not going to be, any coverage for you. One of the things I want to talk about is, and we're going to really get into a lot of this in February or March when we do the part 2 to this, because there's so much involved that, with the other part and the litigation part, which is really interesting. But one of the things I want to touch upon is that when now you've served, your complaint, and you put in your answer, and you really have to analyze and know where you're going with the case in order to figure out where you're going with discovery. Because this isn't like one of those cases where, the typical defense case where you have, the everything's in the can, right? All the defenses are in the can. All your DNIs are in the can. Your bills of particulars are there as well. Your interrogatories may even be in there. If you have any, if you personal injury cases, you can't do interrogatories, but in DJ actions, you can do interrogatories. So you really have to know where you're going. There isn't really just one particular form that's going to, answer every question or get everything out of the other side that you want. And so I think it's really important to make sure that they're very manuscript, your demands, and the things that you want to get. And just to touch upon, and again, we'll get more in depth in the other presentation, but you are absolutely going to want, and now again, I'm assuming that for the purposes of this discussion, as opposed to being the carrier, now let's say you're the insured or the plaintiff, okay? You want to get a copy of that claim file. You want to get a copy of the underwriting file, potentially, if it's applicable, right? You want copies of all of the discovery that went on in the underlying action, right? So, a lot of things are on NICEF. So what I'll do is I get a case, obviously I'm going to go onto NICEF and grab whatever I can from there. But if I don't have access to all the discovery that went on, then if the insurance company is a party to the case or the insured, they should be able to get a copy of that discovery, right? And you want to see what went on because you're going to want to read those deposition transcripts, right? You want to see the BP. So coverage actions, you really have to have a really good working knowledge of the underlying action and what's going on in the underlying action and the discovery and the deposition testimony and all of that. And then you have to know your case. So you really have to know what's going on in both cases. And you also really need to know the liability picture and damages, frankly, in those underlying cases. So, Ware is well versed in the labor law as a labor law lawyer. I mean, we do labor law work at the firm as well, but I need to know the labor law, especially if I'm doing coverage work. And I need to know what the liability is and the liability picture to know where the exposures are going to land on those cases. Okay. So you're definitely going to want all of those things. You're going to want interrogatories because interrogatories allow you the opportunity to ask questions and then you get to depose them, which is even better. So We did put a couple of samples in the materials of ones that we've done. One of them, I think, was an additional insured situation, and that was where I put the discovery demands. The other one was a case where we represented an insured against the insurance company, and I put that complaint in there. And, my other little tip, and probably the last one before Michelle interrupts me, is that if you have a case, right, and you're like, well, what am I gonna, I don't know what to do. I don't know how to formulate this interrogatory or this DNI. Do a search in Lexis or Westlaw, get a case that has a similar fact pattern, look it up in NICEF, and grab the pleadings off of NICEF. I mean, they may not be perfect. You might have, some dispute with things that they say, but it doesn't mean you have to mimic it. It just forms the basis for your drafting. So before we get into the question and answer, I just want to encourage everybody, as I said, if you want to reach out, please reach out to me. I mean, we talk to people all day. This is what we do. And I can at least guide you on your case or how I think you should go forward on it. So we could do the question and answer. There aren't that many, I think, so we might be able to talk about some other things after. So go ahead, Jocelyn. You want to read off right from the top?
Sure. First question, I think I answered, but I just want to throw it out in case you want to add anything. The question was, if there is workers' compensation insurance, under what circumstances will an employer be liable to third parties? And again, that's typically by contract. Again, we typically see that with subcontractors, general contractors, owners. The owner will contract with the general contractor and say, hey, if there's, some sort of claim, you as the general contractor need to provide additional insured coverage because I don't want to be on the hook for it. And then when the GC brings on a sub, they'll have the same provision saying, hey, if there's some sort of claim that you're responsible for, the GC and the owner should not be responsible for it. We should be indemnified by you and we should be entitled to additional insured coverage. So that's typically what we see is kind of these contractual provisions to get around that workers' compensation bar. Is there anything else you want to add, Rosa? Or do you want me to go to the next one?
No, go ahead. That was what I was going to say too.
Okay. Second question would be, is there a procedure for intervening in a DJ action if your client, the injured plaintiff, was not named as a defendant or respondent in the DJ action?
Okay, I thought I saw a question above that one that wasn't answered yet. Hold on one second. Oh, okay. That Michelle must have responded to that. Okay, got it. Okay, so is there a procedure? Yes. So I have done that many times. You make a motion to intervene. The success of a motion to intervene is really hit or miss. It really is. I've tried it sometimes and I've gotten in, and I've tried it other times and I haven't. Now, I think if you have an interest in it, for example, an interested claimant under 3420, like the plaintiff or a co-defendant or something was a cross claim, you have the best chance. If it's just some random person that wants to come into the DJ action, they're never going to get in. But there is a motion to intervene. And like I said, I've done it many times. In fact, let me give you a scenario. Sometimes there are these DJ actions where the carrier started and it's they're trying to avoid the policy ab initio. That's what it's called, right? So what that means, for those who don't know, that means that they're trying to say this policy would have never been in place. They would have never issued it to this insured if we had known this XYZ, right? Something that they didn't make clear in the application, or they lied or something else, okay? And a lot of times when they do that, they bring in the insured and they start the action. And now all of a sudden there are all these plaintiffs out there that are like, wait a second, we want to get involved in this thing. We're going to have no coverage if they win. And I've seen that intervention motions be very successful in those cases. And not only are they successful in the cases, they have settled the cases, because the courts do not like to, in my opinion, and I'd like to hear from somebody if they have a different opinion, they do not like to void policies ab initio when there's injured parties, right? The innocent injured parties. And so they don't do that. So yes, I would say absolutely there is a way to do that. All right, the next question. John Halloran. Hi, John.
Who pays for a declaratory judgment proceeding where the defendant brings the claim after being denied coverage?
Okay. So this is tricky. So, you got to get, what happens is if it's the insured, right, then the insured's going to have to foot the bill and bring in this declaratory judgment action. Now, I'm going to tell you something. And something I meant to mention earlier, which I forgot. So there's advantages to being the one bringing the DJ as opposed to, as an insured, okay, as opposed to just being the defendant in the DJ. If you're a defendant in a DJ action, then there's this theory, it's called that the carrier is putting you in a defensive posture, all right? And there's a bunch of case law on this. And what that means is that because they put you in a defensive posture, if you win as the insured, they have to pay for your legal fees. But if you start the DJ action, then they may not have to pay for your legal fees. Now, there's also a line of cases in the federal courts, and I haven't checked it in a while. I need to shepherdize and see what's going on there. But there was a few cases from the federal courts that actually the insured did bring the DJ action, but the court still found that they were placed in a defensive posture because of what the carrier did in the underlying action to them. All right. So you want to always assert a claim for legal fees. And I do that as well, right? As if you're the insured bringing this claim. Unfortunately, if you're a plaintiff in this case, in this situation, no one's going to pay for your legal fees. It's either, you're going to pay it out of pocket. You're going to pay it from your recovery. Unfortunately, there's no way around that. But again, it's important for plaintiffs to be involved in it. And also when we're talking about this legal fee issue, it's important for the defendants to strategize. I'm going to give you an example. We had a case where the carrier disclaimed and we challenged and they just would not retract the disclaimer. So what ended up happening was we were waiting and waiting and waiting, and there's a time period in which you have to commence a DJ in the policies. So there's a 6-year statute on contract, and sometimes it's a shortened statute of limitations in the policy for 2 years. Maybe sometimes even, I've seen one, but I thought it could only be 2. But in any event, you got to read the policy, whatever it says. So we were kind of like, we're going to have to start this thing soon. And we were waiting to see if they would, I was nudging them to have them start the DJ action. And they finally did. Right. So now, of course, we're going to argue that they're going to have to pay our legal fees if our client's legal fees if we win. Right. They're going to argue that we counterclaimed, so we're not entitled to legal fees. I know the arguments that are coming down the pike, but we're going to argue that they placed us in a defensive posture. So it's a great question, and I think it's a really important strategic question. Okay. Can you provide names or company that does coverage mediation? Yes, the one that I have used is Dan Cohane of Hurwitz Fine. He did a mediation for us, with us, I should say, and coverage counsel on another case. It was very successful, and I will do it again. Okay.
I'm biased, but I worked for Dan my 3rd year of law school. I can confirm that he's an excellent attorney.
Yeah, and he's just a guru in insurance coverage. So you're not pulling any wool over his eyes. He knows every argument. Okay, so how do we combine depositions for a party? Plaintiff in the underlying action where the underlying and coverage claims are not joined. Sorry, Jocelyn, I read for you. Sorry.
That's okay. That's okay.
Yes, great question. So here's how I do it. When the actions are going on, I speak to, I confer with the parties and I say, okay, let's combine the depots, right? Let's combine the defense depot and do part 1 will be liability, part 2 will be coverage. And most of the times I get an agreement. I mean, I don't know, I guess there'd be certain people who wouldn't want that because they want them to testify twice. And technically they're probably entitled to it. It might be fodder for motion practice, but I just, basically I've been very successful in doing that and have the plaintiff's case go first. And that way, if the plaintiff is named in the DJ, I always ask them to stipulate the plaintiff out of a deposition. I mean, he's going to testify twice. He doesn't know anything about coverage, or she. They're just a plaintiff. So I just feel like it's better to have the whole thing combined, and that's how I do it.
I will say sometimes with DJs too, you don't necessarily need depositions of all the parties if they've been done in underlying actions. So it can be very advantageous to read the transcripts. If there's information in there that might support a summary judgment motion, for example, on a coverage issue, you may not end up needing to do the depositions, which is nice if you're more of a motion person.
Yeah, no, and that's a great point. But if they didn't delve into the very specific issues of the DJ, you're going to need the deposition.
Yeah, it's not always something you can avoid, but it can be helpful to at least have those transcripts ahead of time.
Yeah, and you're never going to have a deposition testimony of a claims representative in the underlying action. So you're going to always want to take that, unless the issue has nothing to do with the claim handling, which I don't know what that would be. But so you're always going to want that deposition, and then they're not going to be willing to give up the insured's deposition because you made them go through a deposition. So anyway, okay. Do you want to?
Yeah. Do you send your pre-DJ action coverage dispute letters to the defendant carriers on behalf of the injured clients, or only one representing the insureds?
Oh, no, both. I do both. So I send the pre-DJ action, the pushback letter, as I call it, to everybody. Because one of the things I will tell you that I've done also is, if I'm in a situation, right, where now I see that the defendant is defaulting in the DJ, right? And I'm a plaintiff in the case. But there's a coverage lawyer, and I mentioned this before, there's a lawyer, not coverage lawyer, there's a liability lawyer in the underlying action. I will call them and say, listen, you have an obligation to send this letter to your client. Please send this letter to, because technically, if the defense counsel is assigned by the carrier, their interest is to the insured, not the carrier. That's their primary interest. So they need to send this to their insured. They don't want to get involved in coverage. We're not asking them to get involved in coverage. We're just asking them to forward the letter so that their insured understands, the impact of this.
I saw a request for Dan Cohen's contact information. I'm going to put it in the chat and have Michelle forward it to everybody.
Okay. Can you get that for them?
Yep. So right now.
All right. Want me to read the next one while you do that, or you want to read? Go ahead.
Already set. If the rights cannot be determined at the time of a request for DJ relief per CPLR 3001, for example, unripe medical claims, are the courts inclined to deny relief for these unripe claims, or are they inclined to delay the motion to let the claims ripen within the course of the DJ action?
Yeah, what's happened is, if they're forced, this is what I find, if they're forced to make a determination, like there's a motion for summary judgment, they're just going to have to make it. They can't stop the process, So what happens is, this is what I do, because I have had cases where they're like, okay, question of fact, and now you're left with a question of fact. So, which is not what you want. You knew there was a question of fact. That's how you got into the situation in the first place. So what I will do sometimes is I will talk to the parties, and I'll ask the court if they will delay, if they'll give us, a long adjournment. Sometimes they do, sometimes they don't. It's not happening in federal court. Or sometimes I'll just discontinue without prejudice and then be ready to just jump on it again, because there's nothing you can do, about that. And the court, like I said, once the court's in, if there's motions filed, they have to make a decision. They can't just let it sit there. I mean, they could, I guess, discontinue the motions or adjourn, but that's the best they can do, I think. Unless if someone's listening as a judge wants to speak up. Okay.
What impact does the general obligations law rule against indemnifying parties for their own negligence have on the indemnity obligation to the employer owes the GC or owner or owner?
Okay, so my understanding of this is really more of a liability question than coverage, but my understanding is that the GOL prohibits in construction contracts specifically, prohibits somebody indemnifying for their own negligence, being indemnified for their own negligence, right? So, I'll tell you when this comes up. So I'm going to go back to my example, right? Plaintiff, labor law case. The the employer has an insurance policy, and the insurance policy has an additional insured endorsement that says, we're going to cover you if you have a contract with somebody and you agree to indemnify them, but only for injuries arising out of your work, right? And so, or what's the Burlington language? It's caused in whole or in part by, right? Caused in whole or in part by. That's what the endorsement says, right? Now, that's the basis why the employer's carrier is not taking over the defense or not covering them, as you're saying, indemnifying them, because it hasn't been determined whether it's caused in whole or in part by. Or in your example, it hasn't been determined whether the GC was totally liable for this thing. So that's how that plays into coverage. And it does in a lot of cases. That your issue, you really, pinpointed an issue that comes up quite often in these cases.
A question from Mr. Smiley himself. Hi, Andrew. What is the difference between excess and umbrella coverage?
Okay, this is the trick question. So, all right. So typically, okay, excess coverage is directly excess to a primary policy. That's typically what it is, right?
So whatever's covered under the primary is also covered under the excess, but with bigger limits.
Right. But with umbrella, it's a broader type of coverage. So it might not be directly excess. It might have its own terms. It might cover multiple policies. Like, for example, I'm just going to give you an example. Like, you have a homeowner's policy, right? And you have a primary policy on your home, and you have your cars, right, on the auto. And now you have an umbrella policy that covers both, right, your auto and your homeowner. So that's my understanding of what the difference is. And do you have any other understanding, Jocelyn?
I concur, just that the umbrella might cover losses that aren't necessarily covered by the primary policy. They might be, like you said, broader.
And I actually want to raise something with this, since we do have a little bit of time. One of the things that I have sort of a pet peeve about is that in the defense cases, right, and I was a defendant for most of my career, okay, so I'm not saying anything bad about defendants. This is just the way it is. They're going to send a letter to their insured, their client, I should say, and say, please advise whether you have any excess or umbrella coverage. And the client checks off no, and then signs off. It's hard enough for attorneys to know what excess and umbrella coverage means and priority of coverage and what coverage comes next. How is a layperson supposed to know what that means, right? So I feel very strongly that, one of the things that we used to do is I feel like there needs to be more of an explanation to the insured than just you have umbrella or excess coverage, because it has happened in cases that I've seen where all of a sudden you get to the eve of trial, and now all of a sudden the insured's like, oh, wait a second, I had this other policy, and everybody's scratching their head. How come this policy wasn't ever in play? Now they weren't notified. Now there's going to be a disclaimer. So I really think as a defendant, it's very important. And also, as a plaintiff, when you're asking for confirmation of no excess coverage, again, that's kind of dangerous, because what does that mean? So, I really encourage, and this is really because this is an issue that's coming up in a case that I'm involved in. I really encourage, rather than saying excess and umbrella, you can say any excess, any umbrella, any other coverage that you have. And not just that, because then you're limiting the request to that, and they don't even know what that means anyway. But if they're an individual per se, you could say, okay, do you have let's just say it's, again, the situation where they own cars. Do you have a homeowner's policy? You have an umbrella policy for your homeowners? Does anybody live in the household with you that has has other coverage, has a car, owns another house, anything, and then you can explore it. I'm not saying all those will cover it, but at least you can explore it. And I think it's important for the plaintiffs to be aware that, just using those terms, and the insured, the carriers to be aware that just asking that question, the people don't know what they're asking. And I think it's important to, obviously disclose all the possible policies.
If you're joining us today via podcast, the second attendance verification code is INS225. Again, INS225.
What do you suggest where the insurance company denies coverage but covers defense costs on a provisional basis, subject to a reservation of rights?
Okay. So I have a lot of thoughts on this. That
I
might
have
be
a few, but I'm going to defer to you.
another presentation. All right, here's my thoughts. The carrier is, if they issue a reservation of rights, okay, technically, the insured is entitled to independent counsel at the expense of the insurer. All right. So when they reserve rights, and again, this is like really general because they fight you on this. I get arguments back and forth when it's a true conflict and it's not a true conflict, but just in general for this presentation. So if your client gets a reservation of rights and your client wants you to represent them, then you need to push back and send a letter to the carrier and say, okay, since now you're defending on a reservation of rights, I'm going to defend them at my reasonable rates. All right. And then that's a whole other story I'm not going to get into, but it's what the reasonable rates are. All right. And then you will go ahead and defend because they have to have separate counsel anyway. So let's just say that, like, for example, if they're the only insured is your client, then okay, then they're entitled to independent counsel as one attorney. But sometimes, like in the additional insured situation, the additional insured is entitled to one because they're doing it under a reservation. The additional insured is entitled to coverage by one attorney, and the insured is entitled to coverage by another attorney because there's still a conflict there. So that's the answer to your question in my, and you can also push back. I do that. I've had many cases where I push back on their reservation and I've gotten them to, basically withdraw the disclaimer. Okay.
Are there any new cases or developments regarding insurance policies that disclaim coverage when someone gets hurt on a work site and the policy specifically excludes anyone working on the work site? This is in reference to a labor law situation.
Okay. First, I want to say hi to Craig Deesh, who was there, and I know he said hello to me before, and his question got moved. So how are you doing, Craig? Give me a call. I have to talk to you about something. Okay. So, okay. Are there new case developments regarding insurance? Okay. So this is extremely litigated. I have several of these cases myself. And look, the courts uphold those employee exclusions, but not in every case. I have several cases where I'm litigating the issue because my argument in those cases is it doesn't apply here. It doesn't apply in this case. So you have to look at those very closely. But yeah, the case law is pretty strong on it, that they uphold them, but they still have to be correct disclaimers. So I recommend that you have it reviewed by somebody to determine whether it's proper. All right, go ahead, Jess. I want to get into I'd like to answer everybody's question if possible.
There are a couple of people who threw in some cases involving legal fees and DJ actions. One is Ameriprise v. Hampton. Another one, Mighty Midgets. And we can always put the citations in the chat for everybody if anybody else wants to look them up or if anyone has any questions about them. We did also receive a request for a copy of a pushback letter.
Just send me an email and I can send you something. Okay. Oh, wait, there was another question that I didn't see though. Wait a second. What was the, okay. Go ahead. I just thought I saw, wait, it says legal fees in the DJ action. Wait, plaintiff does not owe answering defendants a duty to defend as there is no recovery for attorney's fees in declaratory judgment action. Okay, I'm sorry. I'll read this out loud. Legal fees in DJ action. See case Ameriprise versus Hampton. It's a New York County case, 2018. Plaintiff does not owe answering defendant a duty to defend, and there is no recovery for attorney's fees in declaratory judgment actions to facilities that submit claims to the insurer on behalf of a non-insured party. I agree with that. So, basically what that is saying is if the plaintiff doesn't owe the defendant a duty to defend, they're not going to owe any defense costs, or they're not going to owe defense costs in either underlying case or the DJ. And then the other one is basically that if there's a non-insured, right, that's how I read this, that's making a claim. So like the plaintiff, the injured plaintiff, remember I've said to you before, the injured plaintiff, they can't get the attorney's fees back. I think that's what that means. So if you think something different, please let me know. Go ahead.
Question. I represent the family of a boy tragically killed in a fire. The boy was in an illegal cellar apartment in Queens, a multifamily dwelling. However, the landlord denied the existence of the cellar apartment, and the carrier also denied. Landlord started a third-party action. Should I look to participate in the third-party action since the landlord clearly misrepresented the existence of the cellar apartment? And what grounds do I have to potentially keep coverage? It's pretty fact-specific. I wanted to ask, who did the landlord bring the third-party action against?
Yeah, we're not going to know unless he puts it in the chat.
Yeah,
you know what, John? Here's what I would say. If you wouldn't mind either giving me a call or emailing me so we can get more details about this, because this is a pretty involved question, and I'd like to be accurate in my answer. So please either schedule a one-on-one with me or just give me a call or send me an email so I can get back to you, and Jocelyn and I will take a look at it. Okay, thank you.
Plaintiff in a DJ is the contractor seeking additional insured coverage. Who do I produce as plaintiff's witness?
The contractor. You have to produce him. I mean, I know it's, right, because in your case, and I'm involved in a lot of DJs like this as well, where the insurance company is not a party, right? It's not a party, not a plaintiff. So this is the defendant is seeking AI coverage. I have a lot of cases like this, either because they don't have any coverage, so they don't have somebody to represent them in it. So you just have to produce your client, and they're going to go over, they're going to go over a lot of things with your client, which, that's one of the things we're going to talk about in the part 2 of this in March or February, March, strategies, because, it's tricky. You want to make sure that your insured is not stepping on his own toes, in the DJ action, and that they know, the coverage position. So it's definitely, you're going to have to produce them, but it's tricky.
Yeah, typically we want to produce the person who signed the contract and or who negotiated the contract, specifically the additional insured requirements. You might also produce someone who's familiar with the insurance coverage or who handles the insurance coverage. But usually for these, we would want to take the deposition of the person who signed the contract.
Okay, let's see, we have 2 more. I think we can get them in.
One is just a comment about, I think this goes back to the umbrella policies, like trying to get them, that you want to use plain language. When you're asking if they have any other insurance policies, you can just say, do you have any other insurance policies? That's it. I don't know if there's a question associated with that. If there is,
and also the other thing is to make sure if you're an insured or an injured plaintiff or a co-defendant or anything, if you're placing a carrier on notice, you want to make sure to ask them, what policies do you have? Not just excess, primary, umbrella, auto. You don't make a coverage determination of what you're looking for under the policy, because then I have a case like this right now where the argument is the demand for coverage under this other policy wasn't made, only the one policy. But so one of the lessons learned from this case for me is when I'm working on the plaintiff's behalf or a defendant's behalf or whatever, I want to ask that carrier, what policies do you have for this insured? Because you'd be surprised, there could be other policies out there, right? They issue package policies sometimes where there's auto homeowner or general liability and auto, or so that's just a suggestion I have.
2 more questions if we can get to them. First question, I understand the rule for attorney's fees is different in federal versus state court. What about with a removed case?
I don't think the rule is different. The rule in federal court, it's the substantive law of the state that applies. It's just a federal procedure that applies. So it's the same rule. It's just that there's some cases that were in the federal court that were very favorable to getting defense costs on a case that was where the insured was placed in a defensive posture. So that's all I'm saying with that. But it's the same rule, federal and state. Okay, let's see. I have 2 questions from Melvin here.
What is the interplay, if any, between an order to show cause and an action for a declaratory judgment?
Okay, so order to show cause would require action be filed. Okay, yeah. So an order to show cause is a procedure during the declaratory judgment action for like a motion or something like that. So it's separate from the actual action itself. And all right, again, I want to thank everybody for coming today. There was a lot of you and some great questions.
Thank you, Rosa and Jocelyn, for providing such a great program on declaratory judgment actions. I look forward to having you back for more episodes. And for my listeners out there, please let me know what you thought. And if you'd like to hear some more content from Rosa, Jocelyn, and maybe some of my other attorneys in the firm. Thanks, and have a great day.